I'm Katie Barlow. Coming up this week on In the Courts, it's a special episode dedicated to Donald Trump's legal troubles. From the hush money case in New York to the Supreme Court hearing over presidential immunity, we've got it all covered with experts to help take you behind the scenes. It was a busy week in the courts. Let's get to it. The week kicked off with opening statements in the Manhattan hush money trial, where former President Donald Trump is facing 34 felony counts for falsifying business records to cover up a sex scandal during the 2016 election. Opening statements, they're a chance for both sides to set the scene and kind of build the narrative they hope sticks in the jurors' minds as they review evidence in the coming weeks. Unsurprisingly, there wasn't much agreement between prosecutors and the defense, including how to refer to Trump during trial. Prosecutors referred to him as the defendant, but his team said, "We will call him President Trump out of respect for the office he held." Prosecutors say this case is about a criminal conspiracy and a cover-up, all aimed at influencing the 2016 election. Trump's lawyer, Todd Blanche, got up and said, "Spoiler alert, there's nothing wrong with trying to influence an election. It's called democracy," he said. And the first witness took the stand this week, former publisher of the National Enquirer, David Pecker. And for the first time, he confirmed the agreement with Trump and his former fixer, Michael Cohen, to buy negative stories and bury them as Trump was campaigning for president. Pecker testified under oath that the deal to catch and kill included a $150,000 payment to Karen McDougal, who says she had a year-long affair with Trump back in 2006. And a reminder here, these payments, they are not disputed and they're not necessarily against the law, but prosecutors say that they were falsified in business records to avoid campaign finance violations. Also, something that came up this week with Pecker's testimony that you're likely going to see again throughout trial: hearsay objections. So hearsay is a statement made by someone who is not in court that's offered for its truth. That's not allowed to come into evidence usually because the person who made the statement isn't there in the courtroom testifying under oath about what they said in order to verify it. But there's a big exception to hearsay, and that's when a statement is offered for some other reason than its truth. For example, when you're trying to show the effect of that out-of-court statement had on the person that was also participating in the conversation. In Trump's case, the defense objected to Pecker testifying about something Steve Bannon said a long time ago. But Bannon is not there in the courtroom to verify it. So Bannon's words can only come in under a very few exceptions to the hearsay rule, and expect these hearsay objections to come up again. And while Trump was stuck in a Manhattan courtroom, forbidden from attending oral argument at the Supreme Court, the justices considered whether he will have to stand trial for his efforts to overturn the 2020 election. Trump argues he is absolutely immune from criminal prosecution. Special counsel Jack Smith disagrees and actually has two federal courts to back him up on that. At argument, the justices seem to agree, at least in part, with Smith that the former president does not enjoy absolute immunity, blanket immunity from any possible criminal prosecution. But they also seem to think that there is at least some immunity for official presidential acts, even criminal ones. And the question of which acts count as official and therefore may be immune and left for a trial judge to determine, that could take some time. And for Trump, whose strategy has been to delay as much as possible, that could be a win. And coming up in just a few minutes, we'll discuss this more in depth with the Courthouse News reporter Kelsey Reichman. Now, let's go now to where all the action is happening, New York City. Reporter Linda Schmidt from our Fox station there is live with what's been happening in the courtroom and what the former president is saying. Linda.
Good afternoon to you and to all your viewers. Yeah, he has a lot to say, as you know, every single day. Anytime that he's got a camera in front of him, he is never short for words, that's for sure. Today, going into court, though, he was very upset. He's especially annoyed about being here today because it is his wife, Melania Trump's birthday, the former First Lady. So he was saying that he's going to be going to Florida tonight when court is over at 5 o'clock to be able to celebrate with her. Now, David Pecker is back on the stand today, and he was cross-examined today by one of Trump's attorneys. And what Trump's defense team is trying to do here is they're trying to cast doubt on David Pecker's memory about certain events that he has testified to. Now, go ahead and take a look at the video here. Now, once again, I'm talking about former National Enquirer executive David Pecker, back on the stand today. Now, yesterday he testified that he had worked directly with Donald Trump and Trump's former personal attorney, Michael Cohen, in a scheme to buy negative, salacious stories about Trump and then bury them so that they would not hurt Trump's chances of winning the election in 2016. Porn actress Stormy Daniels and former Playboy model Karen McDougal have both claimed that they had sex with Trump, something that he strongly denies. Now, one of Trump's attorneys questioning Mr. Pecker about the tabloid industry and how it is just very common practice to pay people for their stories and then either publish them or kill them. In fact, there's a common name for this. It is called catch and kill. And David Pecker said, yes, this happens all the time. He is also trying to poke holes in Pecker's credibility, getting him to admit that he has either mixed up some of the dates and possibly even some of the people who were at various meetings. Now, Pecker is 72 years old. And these events happened back in 2015, 2016, and 2017. Now, as I said at the top, as Trump was entering court today, he was very upset because today is his wife's birthday. He also once again called the trial rigged. But what's bothering him more today, we believe, is that the fact that it is his wife's birthday and he can't be there. Here's what he had to say.
I want to start by wishing my wife, Melania, a very happy birthday. It'd be nice to be with her, but I'm in a courthouse for a rig trial. It's a rig trial. Terrible. But we're doing very well in this rig trial. The case is over. You heard what was said, and the case should be over. But you'll have to make that determination. I think we have a judge that will never allow this case to be over in a positive way. He's highly conflicted. The most highly conflicted judge I've ever seen.
All right, now the former president is charged with 34 felony counts of falsifying business records related to the payoff, that payment to Stormy Daniels. This is something that he has always maintained his innocence on. And by the way, today wraps up the second full week of his hush money trial here in Lower Manhattan. Back to you.
Linda Schmidt, thank you so much for doing the hard work. Boots on the ground there following the day-to-day of this historic criminal trial. We appreciate it. Now, to help us break down what happened inside the courtroom this week and perhaps the strategy that might be playing out behind the scenes, let's bring in Duncan Levin, the former chief of asset forfeiture for the Manhattan District Attorney's Office, now a criminal defense attorney with Levin & Associates. Duncan, thanks so much for joining us.
Good afternoon. Thanks for having me on.
I want right away to get your takeaway from this David Pecker testimony, because the prosecution has been able to elicit a lot of perhaps damaging details about Trump from a man who says Trump was his mentor.
Well, this testimony is so critical to the case, and it's not a surprise that they're putting him on first. This case is really not about falsifying business records, even though that's what Mr. Trump has been charged with. Falsifying business records is a misdemeanor. Falsifying business records with the intent to defraud is a misdemeanor. Falsifying business records with the intent to defraud and to commit another crime is an felony. And so today, for the first time, and this week for the first time, through the testimony of David Pecker, the DA's office's case has finally come into more of a focus. And we now know what that underlying crime is actually. And it's a violation of a New York State election law statute that discusses a conspiracy to basically win an election with unlawful means. And that is what this case now is about. And so they're using David Pecker's testimony to show that Michael Cohen was a conduit between him and the National Enquirer and Mr. Trump to do something that went way beyond what is known as catch and kill, which is a questionable journalistic technique to begin with, where some outlet might buy a story and kill it. They're saying this went way beyond
this conduit relationship with Michael Cohen, because a lot of Pecker's testimony is talking about his conversations with Michael Cohen, which we'll get to Cohen's issues as a witness potentially in a minute. But one of the key things prosecutors have to show here is knowledge that Trump knew what he was doing was illegal. And from Pecker's testimony, do you think we have that yet? That's a high bar for prosecutors, don't you think?
I do think that it's being established. It's going to come in through a number of critical witnesses, both Mr. Pecker, but also Mr. Cohen. Both of those are going to go to show first the conduit between Trump and the National Enquirer and how he directed that and how closely he worked with the Enquirer. But you're right. The prosecutors are going to need to show that Mr. Trump had the knowledge that these falsified business records were being done to cover something up, and that he was covering up some kind of criminal activity. They're using Mr. Pecker right now just to show the criminal activity. They're using him to show the fact that he worked so closely with the Trump campaign, and that this was basically a conspiracy to subvert the election by giving both expenditures and campaign contributions that they weren't otherwise allowed to do. That's what they're using him to show.
You've been in front of dozens of New York juries. How do you put a witness on the stand that has real credibility issues, that is an admitted liar like Michael Cohen?
You know, as a prosecutor, we always used to say to a jury that we don't pick and choose who the witnesses to the crime are. The witnesses to the crime are who they are. If we got to pick, we would go through our Rolodex and we'd go to P and we'd pull out the card that says Pope and we would call the Pope as our witness. But that is not the way the real world works. And it works the same way on the defense side. You get who you get. And so these are flawed witnesses in many ways. They are, Mr. Cohen in particular, Michael Cohen has been convicted of perjury, of lying. He's lied in federal court before. He has a lot of baggage. And so obviously he and Pecker are going to be attacked by the defense over their credibility, and the chips are just going to fall where they lie. But I think at the core of it, there's enough paper trail there to sort of corroborate. And I think the way that the prosecution is going to aim to get through their problems is by corroborating everything they say against another piece of information and say, this case is like a jigsaw puzzle. The pieces fit together. Use your common sense and see how that works.
And just quickly here at the end, you've been a prosecutor, but you also have been on the other side defending a criminal, a charged criminal. Would you tell your client, former President Donald Trump, to take the stand? Do you think he will?
I think there's almost negligible possibility that he is going to take the stand. In this case, he does have something to offer because he could negate the intent. The intent here, remember, is to falsify the business records with the intent of committing another crime. He could get on the stand and say, that wasn't my intent. My intent was to shield Melania from finding out that I was having an affair, or was to, he could come up with some other reason that that was actually his intent. But at the end of the day, I think that it's highly unlikely, because he is going to get absolutely destroyed on cross-examination. The judge is already letting a lot come in. I just think it'd be a terrible choice for him to testify here.
Well, we'll see if you're right on that. Duncan Levin, thank you so much for taking the time to join us.
Thank you.